Who should your children live with when you get divorced, and what contacts should you have? I'm Barrister Daniel Barnett, and to help answer that question, I'm joined today by Barrister Lucy Reed from St John's Chambers. Lucy is a barrister specialising in family law. She's the author of the very good book, The Family Court Without a Lawyer. Lucy, when a couple get divorced, it's often quite difficult to know who the children should live with, and if they are divorcing acrimoniously, it can be quite difficult to sort out contact details between the parents. What are the principles that a court takes into account when deciding who the primary carer for the children is going to be?
So the court has the guidance of Section 1 of the Children Act 1989, which you can look up on the legislation.gov.uk website. And that gives a checklist of factors that the court has to consider. The welfare of the children is the paramount, so the top consideration, the Act tells us, and the court is required to take into account all of the circumstances in the particular case to do with the family, the children and the parents. And the checklist guides the court through the process of trying to work out in the particular circumstances what's best for the children. Should they live with one parent? Should they live with the other? Should they be spending their time between two homes? Or should they have one main home base and be spending time with the other parent? And the checklist that the court has to look at takes into account the wishes and feelings of the child. And obviously the older the child gets, the more important those are. The physical, emotional, and educational needs of the child, the likely effect on a child of any change in circumstances, and that's relevant where before the relationship broke down, the child's been primarily cared for by, let's say, the mother, but in some cases the father. Changing arrangements is going to happen to some extent when parents separate, because the children will spend different periods of time in two homes. But the court will have to think about whether or not it's right to disturb the primary care arrangement, if that's how things have worked in the family up until that point, or whether things need to change, whether there can or should be a more shared care kind of arrangement. And the other factors are age, sex, background, and any particular characteristics of the child that are relevant, any harm which the child has suffered or is at risk of suffering. In this type of case, that could be all sorts of things, but typically if there is an issue around that, it might be to do with allegations of domestic abuse, which are where there's domestic abuse, it's harmful to children. And then the capability of the parents. So if there are issues about their ability to manage the needs of the children, whether generic needs or particular specific needs the children have. And then the court has to look at the range of powers that it's got available to it. And generally, the court will obviously consider the views and the evidence of each of the parents. Sometimes it will need some assistance from CAFCAS, who are the Children and Families Advice Service. And CAFCAS will prepare a report to help the court think through those factors. They will have met the children, they'll have met the parents. Quite often they'll have observed some contact to see how the children relate to each of their parents, and they'll make some recommendations, which will be quite important for the court in coming to a decision. Sometimes if there are allegations of domestic abuse and they're going to be relevant to the decisions the court makes, then the court will have to first of all have a hearing called a fact-finding hearing to decide whether those allegations are true, and then once the court has made those decisions, to think about, well, what does that mean in terms of the decisions we need to now make for contact and living arrangements? Do we need a risk assessment? Do we need an expert report? Can we go ahead and make some decisions without any of that?
So let's take a situation where you've got two parents, a mum and a dad, who are both very responsible. There's no risk of issues with safety to the children. Both parents want to continue being the primary carer for the children, and they can't agree who the primary carer should be. Is there an age at which the children's wishes get to actually make that decision? So you can see how a judge wouldn't necessarily follow what a 6-year-old says, but might a judge pretty much automatically follow what a 16-year-old wants?
By the time you get to 16, the court's unlikely to be making an order at all. An order after a child's 16th birthday can only be made in exceptional circumstances. But if you're thinking about children in secondary school years, the further they go up in age, the more important their wishes and feelings will be. And on a practical level, you'll often hear judges saying, well, the child is going to vote with their feet. So there comes a point where even if the court thought the child should be living with, let's say, the father, but the child really wants to live with the mother. Children do sometimes vote with their feet. And then really the question is, how does an order help in that situation? But each case will be different. And although it's generally right to say that the older the child is, the more weight their wishes and feelings will carry, there are some circumstances where children will be expressing a really strong and fixed view that they want this or they want that, but there are very good reasons why the court can't rely just on what they're saying they want to happen.
Let's say the primary carer is the mother and the father wants more contact, but the mother doesn't agree. How does the court decide how much contact to allow?
Again, that will be different as between different cases, because the circumstances will vary. There are obviously different working patterns for parents, different vulnerabilities or limitations on particular parents. There may be a need for supervision of contact in some cases, but generally speaking, the court will want, assuming all other things are equal, for children to be spending regular and decent amounts of time with the parent that they're not living with. And there isn't a standard or automatic default arrangement, but very often that will mean if there isn't a truly shared care arrangement, spending time on, let's say, alternate weekends, so that each parent gets to spend some weekend time with the children, and maybe spending some time with their other parent one night during the week. It will vary depending on the particular needs of the children and the arrangements for the parents, but that might be the sort of thing that the court will be looking at. And then, of course, there will be different arrangements in the holidays, and very often, again, all things being equal, the court will say, well, you can share the holidays equally, and there's any number of different ways of splitting up the holidays so that they're broadly equally distributed, but so that it works for the children.
Thank you very much, Lucy Reed from St John's Chambers. If you found this explainer guide helpful, please do subscribe and click the notification bell. I'm putting together a series of explainer videos on all different aspects of UK and English in particular law. Thank you so much for watching. I'm Barrister Daniel Barnett. Bye-bye.